I'm David Birchie. I'm a trial lawyer in the field of catastrophic and insurance law. As a board member of the Canadian Society of Medical Evaluators, I'm very pleased to introduce Andrew Rudder, who will be speaking on the new automatic CAT definition, discriminatory ramifications based on geography. Please post any questions you have to Mr. Rudder using the Q&A function. Andrew was called to the bar in 2010. He's a personal injury lawyer who practices in the field of catastrophic impairment. Unlike many, Andrew not only practices what he does, but he also teaches and he publishes. He's got a book that has been published by LexisNexis. And without further ado, I'm looking forward to hearing from my friend Andrew to talk about this interesting topic. Thank you.
And thank you, David, for that introduction. And hello to everyone. It's a pleasure and an honor to be here. During my presentation today, I'm going to begin by telling you the story of a catastrophically impaired client of mine whose case revealed a legal glitch so obscure that even the people responsible for it didn't know it existed. A glitch that nearly cost her up to $1 million in insurance money. I'll then tell you how it inspired me to dig deep into arcane legalities to come up with a win for my client, her troubled family, and other catastrophically impaired children in Ontario who sustained severe traumatic brain injuries as a result of motor vehicle accidents. I'll end by pointing out an ongoing issue for you to think about, and then I'll provide a solution. So 3 years ago in 2018, I was a Toronto-born personal injury law lawyer working in Hamilton, AKA the Hammer. I got my first catastrophic impairment case, which I didn't know would profoundly impact me, take me on an incredible journey, and change the course of my life in ways I couldn't have possibly imagined at the time. The case involved a 17-year-old Indigenous girl who was born in and lived her whole life on the largest First Nations reservation in Canada, the Six Nations of the Grand River. My client was an exceptional horse rider who wanted to pursue her chosen career path as a horse trainer. She was around horses from the age of 5, cared for, rode horses most of her life, and owned horses in a stable located behind her mother's house. She owned a horse named Smoothtown and a pony named Jade. She trained Smoothtown to compete with her in many barrel horse racing exhibitions in Ontario. It even qualified for the World Barrel Horse Racing Competition in Atlanta, Georgia. In the first quarter of 2018, about 7 months before her motor vehicle accident, she gave birth to a beautiful baby boy. However, the birth of her son was tragic. After sustaining seizures during birth due to undiagnosed preeclampsia, her baby was born flat, blue, and not breathing. The pediatrician was able to resuscitate her son, but with significant brain damage, weak organs, and a reliance on a feeding tube. Despite the fact that she was the primary caregiver to a severely disabled child who would need a team to care for him and help satisfy his significant developmental needs, he provided my client with a renewed sense of purpose. In the second quarter of 2018, she experienced a tremendous tragedy close to home after her younger brother committed suicide. However, through the support from her immediate family and close-knit community on the reservation, she was progressing through the natural bereavement process. Finally, in the third quarter of 2018, tragedy struck again. Just before she was about to leave to Atlanta to compete in the World Barrel Horse Racing Competition, she was a seatbelted passenger inside of a vehicle being driven by her cousin at a high speed of 100 kilometers an hour. Her cousin lost control of the car, flipped the vehicle on the roof and into a ditch before crashing head-on into a tree. My client was catapulted forward headfirst through the windshield and sustained a severe traumatic brain injury as well as multiple fractures. At the time of the motor vehicle accident, the Ontario government had recently introduced a new automatic catastrophic impairment definition for children, which came into effect on June 1st, 2016. I thought it might be applicable to my case, so I did what any young lawyer would do. I took a deep dive approach to discovering the answers to the questions I sought in order to advocate on behalf of my client. I completed a comprehensive review of my client's entire medical file and researched the medical literature on traumatic brain injuries in children. I searched for legal precedents that extended the application of the criteria of the new CAT definition to cases, but to no avail because the law was so new. However, I believe very deeply that my client satisfied the 3 criteria, so I sought the medical opinion of a pediatric neuropsychologist who agreed with me. The doctor completed an OCF-19 form and sent it to my client's insurer. The insurer retained a neurologist who reviewed the radiological studies with a computerized axial tomography scan of my client's head, which showed conclusive evidence of intracranial pathology. The insurer's neurologist also concluded that my client suffered a traumatic brain injury as a result of a motor vehicle accident. Case closed? Well, no. The insurer still denied my client a catastrophic impairment designation because she didn't satisfy one of the 3 criteria. My client's mother, who was a single mother of 4 children, was devastated. She didn't know what she was going to do and how she was going to pay for the exorbitant expenses of treatment, care services, and support for her teenage daughter. She didn't have time to unravel the bureaucratic knot that was going to cost her struggling family up to $1 million in insurance money. She was too busy caring for a catastrophically impaired daughter and a severely disabled grandson while running the corner store she owns on 6 Nations. The first criterion required my client to be admitted as an inpatient at a lead trauma hospital listed in the Insurance Act Superintendent Guidelines number 0116. As you can see in the slide, the guideline lists 12 level 1 trauma centers that the province has decided qualify to properly treat traumatic brain injuries. Since my client sustained multiple fractures in addition to suffering a severe traumatic brain injury, she was first admitted as an inpatient to the 6th South Surgical Trauma Unit within the Hamilton General Hospital because she required immediate orthopedic surgery, which took priority over her head trauma. However, the Hamilton General Hospital, a level 1 trauma center, was not on the guidelines list of 12 level 1 trauma centers. One of the 2 Hamilton hospitals that was on the guidelines list was the Regional Rehabilitation Center. The Hamilton General Hospital and the Regional Rehabilitation Center are within the same hospital network, the Hamilton Health Sciences, and are literally connected to each other by a bridge. Since my client's spinal surgery was a priority in the moment, she was admitted as an inpatient on the wrong side of the bridge. The failure to include the Hamilton General Hospital in the guidelines was a bureaucratic glitch, which was going to cost my client hundreds of thousands of dollars in much needed medical and rehabilitation care services and support. When there's a vulnerable, marginalized group being denied justice because of an imbalance of power with a large corporation or the government, that pulls my heartstrings. This injustice made no sense to me, and I couldn't sleep at night, as I couldn't stop thinking of my catastrophically impaired client and her family. So I took a deep dive into the evolutionary changes of the catastrophic impairment definition from 1996 to 2016 in order to better understand the government's underlying rationale for creating a new catastrophic impairment definition for children. I undertook a modern approach to statutory interpretation to show that the insurer's interpretation of the guideline did not harmoniously coincide with the main objectives of insurance law, the purpose of insurance contracts, the scheme of the Remedial and Benefits Conferring Insurance Act and the relevant regulation, and the intention of the Ontario legislature within the broader context of the evolutionary changes in a definition of catastrophic impairment. I presented the insurer with a sound, comprehensive argument, and they eventually overturned their denial and granted my client the catastrophic impairment definition. The designation increased my client's accident benefit policy limits from $65,000 to $1 million. I was happy with the result for my client and her family, but it didn't feel like it was enough. I wanted to do more when I began to realize the provincial bureaucratic glitch I uncovered didn't just adversely affect my client, but also other children with traumatic brain injuries who lived in rural communities and remote areas that were far away from the guidelines list of 12 hospitals. I concluded that the guidelines interpretation of the new law had discriminatory ramifications based on geographic location, which had to be changed. I was reminded that as a lawyer, oral advocacy transcends beyond a mere legal retainer of a client and extends out to the larger community and broader social justice issues. One decision for my client impacts the life of one child and her family. If, however, I change the law, then that would impact the lives of thousands of children and their families. It was at this pivotal moment that I decided I would change the law in Ontario. I started raising awareness by telling as many personal injury law lawyers as I could about what I uncovered, and then by writing a 6-part series that was published in the Lawyers Daily in April and May of 2019. I raised more awareness after being featured in the cover story of the Hamilton Spectator on July 16th, 2019. The front page newspaper article was written by a social justice columnist named Susan Clermont, and it was entitled "Injured Girl Denied Insurance Claim Due to Province's Bureaucratic Glitch." The article included quotes from myself, my client's mother, various provincial government bodies, and the Hamilton General Hospital, as well as from the Ontario New Democratic Party leader, Andrea Horwath, who embraced my solution for the changes that needed to be made to the insurance law. After this article was published, I obtained the support of the Ontario Trial Lawyers Association. I then reached out to the Financial Services Regulatory Authority of Ontario, who administers, regulates, and enforces the Insurance Act. I met with their senior manager on policy interpretation, as well as their senior in-house counsel, and I persuaded them to amend the Superintendent Guidelines number 0116. Effective October 17, 2020, the old guideline was replaced by the new Guideline on Public Hospitals and Determination of Catastrophic Impairment. FSRAO included all level 1 trauma centers in Ontario, including the Hamilton General Hospital, further to the lead trauma hospitals accredited by the Critical Care Services of Ontario, which is the managing body that's responsible for the overall program implementation of the critical care strategy and the Ontario Critical Care Plan. The change is a great first step forward in the right direction, but unfortunately for me, it doesn't go far enough to eliminate the discriminatory ramifications based on geography, which is the ongoing issue I alluded to at the outset of my presentation. I explain why in much more detail in my book, Catastrophic Impairment Law in Canada, which is published by LexisNexis, as David said at the outset. Here's my solution. I think the new guideline should also include level 2 trauma centers. Why? They are closer than level 1 trauma centers to the smaller level 3 trauma centers, which typically exist in smaller rural communities and remote areas. Since level 2 trauma centers are capable of handling the majority of major trauma care that level 1 trauma centers can, if a child sustains a catastrophic TBI in a rural community or remote area in Ontario, then further to the transfer agreement, protocols, and policy set in place at the level 3 trauma centers, the child will likely be transferred to a level 2 trauma center, which isn't currently listed in the new guidelines. However, once listed in the new guidelines, the child who is admitted to a level 2 trauma center and meets the other 2 criteria would also obtain a catastrophic impairment designation. Thank you, ladies and gentlemen, for your time.
Thank you very much, Andrew. That truly was inspirational, and congratulations to you for all your effort and for helping so many. I think we'll look at some questions, and we're taking questions from the audience. So I leave it to Dr. Nemeth and to you to enjoy the questions. And I appreciate very much, we all do, you coming today and speaking to us. Thank you.
Thank you.
Thank you, Andrew. I don't actually see any questions posed in the Q&A, but as I was saying, you might get some questions later. Mr. Birchie, do you have any questions for Mr. Rudder before we move on to our next speaker?
I think Andrew did a great job, and I'm very proud to know Andrew and to enjoy what he's shared with us. And I encourage people to read his book.
Awesome. Thank you.